Good afternoon, everybody. Welcome to this webinar on business interruption. This is part of our 39 Essex Chambers 39 from 39 programme of webinars during this period. My name is Jonathan Bellamy and I'll be chairing this webinar. We have over 300 participants attending today from the Middle East, from Singapore, and of course from the UK. Many will either have a cup of tea, an early evening drink, or possibly even a nightcap, depending on their time zones. The participants are solicitors, in-house counsel, insurers, reinsurers, Lloyd's market, brokers, loss adjusters, commercial policyholders, and business owners. Practice areas and business sectors, in addition to insurance and reinsurance, include commercial, construction, retail, hospitality, licensed trade, sport, and entertainment. Our format today will be of 3 speakers, each speaking for about 10 minutes, and then time for a Q&A session via the chat button, should you wish. Edmund Townsend will speak first on extension cover for notifiable disease. I will then speak on extension cover for non-damage denial of access, and Neil Block QC will then speak on causation of recoverable loss. We may not be able to respond to all your questions fired via the chat button, but we'll do our best. If we can't answer any of those questions today, we don't have time, we'll endeavour to answer those by email later. This webinar is being recorded and will be available on our website in due course, probably from Thursday, which can be viewed and accessed via our homepage. If you require CBD points, the provider is 39 Essex Chambers. Very brief introductions about our speakers today. Neil Block was called to the bar in 1980 and took silk in 2002. He has a wide-ranging practice, acting mainly for insurers, large institutions and the government. He regularly advises on a range of policy coverage issues and has recently advised regulators, insurers and policyholders on business interruption and other COVID-related points. My insurance and reinsurance practice comprises litigation, arbitration and advisory as counsel. The work covers all issues arising in policy, interpretation and coverage relating to the full range of indemnity, contingent and financial line covers. This experience covers and includes policies governed by other civil law systems and common law systems. I also have an active practice as a chartered arbitrator in this sector. Edmund Townsend, before coming to the bar, Edmund was a research assistant with the commercial and common law team at the Law Commission, where he was assigned to review insurance contract law. Edmund spent over a decade lecturing in the law of insurance and as a teaching fellow at University College London, where he convened the module on insurance law, the LLM. He is regularly instructed to advise and appear in court in relation to policy wordings. So with that introduction, I'll hand over to Edmund Townsend.
Thanks, Jonathan. I'm going to be speaking about non-damage extensions relating to notifiable diseases. They're quite commonplace in composite commercial policies, especially in the hospitality and leisure sectors. I've set out on the first slide there some different wordings that you may come across in relation to insuring clauses. So the first is relatively self-explanatory: any occurrence of a notifiable disease at the premises. The second, the discovery of an organism at the premises which is likely to give rise to the occurrence of a notifiable disease. That is concerned with a causative agent, and so it recognises that a defined loss to the business may arise, or even cessation of trade, because steps need to be taken to prevent a notifiable disease occurring at the premises once a causative agent is found. In relation to COVID-19 or coronavirus disease, the causative agent is severe acute respiratory syndrome coronavirus 2. There may be an issue about whether that's embraced by the word organism or not, and that is something that you may require detailed expert evidence about in order to determine. I'm not going to speak to you about causation in detail because Neil's going to speak to you about that later. But suffice to say, in relation to those first two forms of policy wording, it's likely that there's going to be difficulties in relation to causation, either in establishing that there has been an occurrence at the premises itself, a notifiable disease at the premises, or either that the causative agent has been at the premises, as well as establishing that loss flows directly from the presence of the causative agent or occurrence of a notifiable disease at the premises. The third wording is likely to be of more interest. So any occurrence of a notifiable disease within a radius of 25 miles from the premises. You will also find wording like that, but with a different figure in terms of the parameters and proximity to the premises. So you may see 1 mile or 50 miles, different wordings that are used. The origin of that sort of wording is obviously to recognise that businesses may be affected indirectly by a notifiable disease as well as directly when it's at their own premises. And so it envisages an indemnity where there is a notifiable disease that proves that causes a proven tail off in the business or cessation of trade, even though it's a distance away from the insured premises. It may be suggested by insurers that that sort of wording is intended for a localized instance and that it was never envisaged that it would respond to a pandemic. And so there could be arguments about its application in the context of a pandemic, whether it deals with an instance where there is more than one occurrence, or indeed where there's more than one occurrence and one occurrence is within the radius that's identified and it's more widespread, there are occurrences outside that radius. But subjective intention of insurers in drafting the clause in the wording in the insuring clause is not something that is relevant to the construction of the clause. Obviously, what we're concerned with is the objective intention of the parties. And on the face of it, when you look at that wording, it isn't confined to a single instance, and it doesn't expressly deal either with a situation where there's a notifiable disease inside and also notifiable disease occurrences outside of the radius that's identified. So in principle, there's no reason why cover ought not to respond to multiple occurrences of notifiable disease, whether they're widespread or not, albeit subject to particular arguments in relation to the cause of proximate loss. And that's why you need to pay attention when Neil speaks later. So what is a notifiable disease? Well, as ever, when dealing with insurance, you need to look to the policy terms themselves. Usually it will be a defined term. Often you will find that there is a list of specific diseases. Where that is prescriptive, then it is likely that there won't be much scope for disagreement. It's clear cut. It's either on the list or it is not. And almost inevitably, coronavirus disease and the causative agent are not going to be on the list because they only became identified in February of this year. You may also come across, though, more general formulations within the list, and it may provide for mutant variations of other diseases that are identified in the list. Again, that is something which will require expert evidence in order to determine whether coronavirus disease is indeed a variation from something on the list. Some policies won't have a definition, and in those instances, it is helpful to bear in mind case law from other common law jurisdictions. So in Hong Kong, there is a case, the New World Harbour View Hotel case that arose out of the SARS outbreak. And so in that case, the insurance clause there is set out at the top of this slide. It's worthy of note there are two insured perils identified in that one clause. There wasn't a SARS outbreak at the hotel concerned in that instance, so they were relying upon the second aspect, the second insured peril, whether there was a notifiable human infectious or contagious disease within 25 miles of the premises. And factually, the government in Hong Kong had requested both public and private hospitals to report all cases of SARS as of from the 11th of February 2003, but they did not add SARS to the first schedule of quarantine and prevention of disease ordinance as it then was until the 27th of March. So it only became mandatory, a requirement in law to notify from the 27th of March. The case was dealt with by the Hong Kong Court of Final Appeal, and retired Chief Justice of Australia, Sir Anthony Mason, delivered the judgment of the court. And in essence, it was found that a notifiable human infectious or contagious disease is one that was required by law to be notified to authorities. So the SARS outbreak was not an insured peril under that policy until the 27th of March 2003. Now, obviously, what that means is that you need to be mindful and aware of the date upon which coronavirus disease and its causative agent, SARS-CoV-2, became notifiable within the jurisdiction in which you are operating. I've set out on this slide the framework by which coronavirus and SARS-CoV-2 became notifiable. Within the United Kingdom, it's different in Scotland, Northern Ireland, England and Wales. In bold is the date that you need to be concerned with. So Scotland, it's the 22nd of February 2020. Northern Ireland, the 29th of February 2020. England, the 5th of March. And then in Wales, the 6th of March, all of this year. Once you've considered whether it is arguable that the facts of your case come within the insuring clause, you also obviously need to check exclusions because they are common and widespread for this form of extension of cover. And much like insuring clauses, it may well simply list a specific disease or conditions, in which case COVID-19 is unlikely to feature. You'll have the same sorts of arguments where there is a more general formulation or a reference to mutant variations, but it's also quite common to come across more specific exclusions that are targeting flu-like symptoms and diseases that cause them that are prone to pandemics. So any pandemic, influenza or strain identified by the World Health Organization, or any pandemic, coronavirus or strain identified by the World Health Organization, will be the sort of wording that might be used to try and achieve that intention. Thank you for listening. I'm going to hand you back to Jonathan now, who's going to talk to you about denial of access.
Thank you, Edmund. Thank you very much indeed. Right, so I'm going to be speaking to you about non-damage denial of access. The first point that I'd like to discuss and get over as an important message is that this is very much the exception, not the rule, even where there's an exception by extension. The general rule in most BI policies is that there is a material damage proviso. Now, this is reflective of the fact that most BI covers are sold with property damage cover. All basic covers and most business extensions are dependent on physical damage to premises, whether themselves or in the vicinity, in a wide area damage clause. Non-damage DOA covers are therefore a minority subset of DOA cover. The likely event in most cases which will trigger cover under such an extension is the act of an authority in closing or potentially restricting access to premises. Good examples in the current situation are, of course, cafes, restaurants, gyms, and hotels. The very inelegant acronym NDDOA cover can be provided by extension in a number of ways. And each of those ways, as ever with insurance, requires a very careful analysis of the language used. First, the language used in the extension can be wider than that used in the basic property or indeed the basic business interruption cover. This may be deliberate or it may be inadvertent, arguably because no defined term is used in the extension. Therefore, one finds situations in which the word damage is used in the basic cover, but in the extension cover, one might find loss or damage, and those words are not defined by use, for example, of capital letters. Thirdly, one has a situation where there is deeming language used in the extension, so that events and occurrences which are not normally physical damage are deemed to be such for the purpose of the extension. Freedom of contract clearly permits the parties to do that. It is an example of risk allocation and will be, in almost all circumstances, upheld by the court. Even when you've crossed all those bridges and you bring yourself within the exception to the rule, it's important to read, of course, to the end of the clause to consider any exclusions, because in a number of policy wordings which are out there at the moment, notifiable or infectious disease is an exclusion to the extension itself. I turn next to look at some of the triggers for the NDDOA form of cover. As I've already said, the extension may use the term loss with or without the word damage. It may use other language such as interruption or interference. And where it uses the word damage, it may not be using it in the normal defined term. What then is the trigger for policy coverage if loss or damage is not a defined term subject to the material damage proviso? Now, one example here is whether or not it can be argued on a given set of facts, of course, that extended deprivation of use can equal or constitute loss for the purpose of a loss and damage clause. Probably the most helpful analysis of this is the Court of Appeal's treatment of the clause in question in Scott and Copenhagen Reinsurance Company, a case involving the loss and destruction of aircraft, in this particular instance, Kuwaiti airline aircraft, during the course of the Gulf War. A case on aggregation, technically, but when one looks at the dicta, for the purpose of aggregation, it was necessary to establish when the loss took place under the terms of the contract. Suffice it to say, for today's purposes, that it may well be arguable that loss can be satisfied where there is such an extended deprivation of use that there is a denial of function. Some of the old cases, Moore and Evans, well-known cases about loss of jewels, or detention, I should say, of pearls during the First World War, have a more limited approach to this, but there may be scope in the future for that. What then is the trigger for policy coverage if there's no physical damage? Again, some of the consideration here requires a granular examination of the wording used in current policies. Some of the policies use the phrase, the presence of an organism, a notifiable disease, or a danger on insured premises or in a wider area. Edmund has obviously spoken on notifiable diseases just now. Whether a virus is an organism is a truly difficult question that even scientists have different views on. Whether the presence of the coronavirus on the premises or in the vicinity in a WAD clause is a danger is an interesting question. I think it would be right to say that most of these extensions were written on the basis of civil disturbances, crimes, and closures by the police. So one's always going to come back to arguments on insurers' part about whether or not that is the true purpose of the policy. Interesting arguments about how generally you construe clauses with that in mind. As I said with the first slide, we have triggers such as the order, the action, or in some cases, even the advice of a public authority, civil authority, or competent authority, clearly intended to be wider than just police putting up cordons where there's been a crime. And then we have the question of prevention of or hindrance to access to premises. Hindrance to is plainly wider than prevention. The extent to which the test of hindrance is satisfied in the current circumstances, particularly when one considers the direct requirement of consequence in causation, which in part Neil will speak to in due course, is a very interesting question. I turn then in the final two slides to some policy wordings, just to bring home the reality of these important points. Two slides here on some NDDOA wordings. The first relates to interruption or interference, plainly wider language than damage. The very same clause includes the requirement of direct consequence of the intervention of a public body. Intervention is a broad word. The implication or express reference rather to direct consequence is a narrowing. At the premises, this clause requires the presence to be at the premises rather than in the area or outside the premises. The point on the organism I've discussed already. A second form of clause there for your consideration is more relaxed in terms of in consequence and has a deeming provision. And there you have an example to look for when you're examining this type of clause as to whether something should be deemed to be an incident. That's the clause which refers to a danger or disturbance. Now again, interesting as to whether or not those words more easily lend themselves to immediate physical danger rather than a public health emergency caused by the coronavirus. And this itself is an example, after jumping all these hurdles, whether or not an infectious disease has been declared a pandemic and is then therefore excluded. Finally, I'm going to turn to the following wordings. Here we have a clause which talks to an incident. Now, again, as a matter of language, not being a defined term, can we truly say that the event of or presence of coronavirus in premises or nearby is an incident? Then we have the question of a denial or hindrance of access. Concrete examples in this case are, for example, whether requirements for social distance working in premises hinders the access, for example, on public transport or not, to premises. Some covers only provide for expenses resulting, in this case, sold indirectly. Seems to me that this would be a case limiting it for increased cost of working only. Others have cover for much wider, more conventional increased cost of working and loss of income or gross profit, measure of damages and indemnity in business interruption cases. There we have a clause, any losses arising from interruption. Finally, I'm going to leave with you this point, which is in a sense a solid link with the causation point that Neil's going to talk about. One of the clauses that does appear in these cases, and these cases came in from the US, particularly with Hurricane Katrina, some of the hotel cases in that jurisdiction, and are referred to as business trends policies. They're a quantum point, but you'll see by the underlined words there that they do reflect any special circumstances applicable before or after the loss, which will affect the amount recoverable. And the important words at the end there are the result that would have been achieved if the insured damage had not occurred. So even if you can bring yourself within the liability aspect, it does seem to me that insurers will have arguments that can be made about the loss of profits and the rest that would have been sustained even without the NDDOA cover within the terms of the policy. So with that presentation, I will now hand over to Neil Block.
Good afternoon. I'm going to talk to you briefly about the but-for test in the context of business interruption insurance claims. I suspect that many of you will know the old joke about the policyholder making a claim only to be told, yes, your policy does cover your fall from the roof, but unfortunately it doesn't cover you for hitting the ground. In a sense, that's what we're looking at here, where the policy on the face of it seems to provide cover, but then the insurers deny that that cover's applicable. So I'd like you to consider the position when a business suffers a loss by reason of the presence of an infectious disease at the premises or within the defined location, but would in any event have been unable to trade by reason of the lockdown regulations. And the question is the loss resulting from the presence of the infectious disease at the premises recoverable? Now, as Jonathan said, the standard business interruption clauses nearly always only cover loss arising from damage to the property, but I'd like you to assume here that we are looking at the case where there is a loss that is insured under the policy, and the leading authority on that is Orient Express Hotels and Generali, a case that came on appeal to the Commercial Court in 2010 from the decision of arbitrators. This claim arose in the aftermath of Hurricanes Katrina and Rita in New Orleans in 2005. The claimant hotel had the benefit of an insurance policy which covered business interruption directly arising from damage, and damage was defined as direct physical loss, destruction, or damage to the hotel. There was a trends clause that provided variations or special circumstances that would have affected the hotel business had the hotel not been damaged to be taken into account. So that the figures thus adjusted shall represent as nearly as may be reasonably practicable the results which, but for the damage, would have been obtained during the indemnity period. And the policy was governed by English law. Now, the hotel had suffered significant damage in the hurricane, and it was agreed between the parties that this had caused interruption to the running of the hotel. It had in fact been closed for a period of about 2 months. But the surrounding area was devastated by the hurricanes, with the entire city being shut down for several weeks following a declaration of emergency and the imposition of a curfew and mandatory evacuation. There was also an issue as to whether that interruption of business by reason of the damage to the hotel was the cause of the hotel's loss of income within the meaning of the policy. Now, the insurers contended that the policy only covered loss that the insured could prove would not have arisen but for the interruption of its business due to the damage to the hotel premises. And you can see what's coming, can't you? And that since the damage to the city in which the hotel was located was a concurrent and major causal factor, there would be no indemnity under the business interruption section of the policy. In other words, the loss would have been suffered by the hotel as a result of the damage to the surrounding area, even if the hotel itself had not been damaged. The arbitrators accepted the insurer's argument. No award was made under the business interruption section of the policy, and limited awards were made under the loss of attraction and prevention of access extensions to the policy. The hotel appealed to the commercial court, and it's important at this point just to step back and acknowledge that therefore the court was exercising an appellate function rather than determining the issues strictly on their merits. Mr. Justice Hamlin heard the appeal. The question for determination was whether it was appropriate to use the but-for test in relation to causation where there are two concurrent and independent causes, one of which fell within the policy cover, that's the damage to the hotel, and one of which was specifically excluded, that was the damage to the surrounding area. And the distinction was drawn between interdependent concurrent causes and independent concurrent causes. So for interdependent concurrent causes, where one can't necessarily happen without the other, the but-for test would be satisfied. But for independent concurrent causes, it would not. Now, the hotel argued that decisions such as in Miss J.J. and Silversea Cruises and similar cases should apply. Now, in those cases, it was held that where there are two proximate causes of a loss, the policyholder can recover if one of the causes comes within the cover, provided the other is not excluded. And the hotel also sought to rely upon the relaxation of the but-for test in the Kuwaiti Airlines and Iraqi Airways case in 2002, in which there were two joint tortfeasors, and the court found them both to be liable, even though the claimant couldn't prove which one of them had actually caused the loss. So this being an appeal, the judge concluded that the terms of the insurance contract were express and clear, and that fairness and reasonableness didn't require him to set aside the arbitrator's finding. There'd been no error of law, and Mr. Justice Hamlin accepted that the above authorities were distinguishable in that they involved interdependent causes as opposed to independent causes. He did accept, and this is encouragement for practitioners, that there may be cases in which the but-for test should not apply, and he gave permission to appeal to the Court of Appeal. Unfortunately for us, the parties compromised that appeal, and the Court of Appeal therefore has never considered this issue. Now, Orient Express has been criticised by various academic and practitioner commentators who argue that it deprives the policyholder of the cover intended to be afforded under the policy and gives a windfall to insurers. And the argument that is put forward is that the policy should respond up to the level of loss that would have flowed from the damage to the insured's premises, notwithstanding the wide area damage. The damage to the hotel in Orient Express meant that the hotel had to close for 2 weeks. The business was interrupted for those 2 weeks, and the academic argument is that the policy should have responded because that is what the policyholder paid for. It's surprising this issue has still not been considered by the Court of Appeal, but pending such an appeal, which of course we have to accept may not reach a different decision than that reached in Orient Express, policyholders may wish to instruct their brokers to seek cover that includes a trends clause that provides for the policyholder to be placed in the position it would have been but for the event causing the damage, as opposed to the current wording of most policies, which is but for damage to the insured's premises. You may find it interesting to note that the Orient Express approach, which is still good law, was not adopted by the London market when dealing with claims involving large areas of damage in the Cumbrian floods of 2009 and in the Thailand floods of 2011, insofar as policies were subject to English law provisions. Now, this may be because the insurers accepted that the true intention was to provide cover in respect of losses flowing from damage to the insured's premises and notwithstanding the wide area damage, and that insurers didn't wish a ruling to that effect by the Court of Appeal. And finally, I would suggest that when brokers are being asked to place cover, that there is much to commend seeking adequate levels of cover under the loss of attraction and prevention of access clauses, which in the 24 or so policies that I've looked at since lockdown seem to universally have very modest limits. Thank you very much.
Thank you, Neil. The last few minutes that remain for us, we're going to answer a few of the questions that have come in. We certainly can't answer them all, but we're very grateful to those who have taken the time to ask some questions. Council's time estimates are notoriously bad, so we're going to do our best to stick to the time that we said. Edmund, the first question that I was going to offer for you was really quite a straightforward one, but nonetheless one that's plainly affecting the questioner's caseload, and that's this. Can COVID constitute the plague within the meaning of that word used in a policy?
I think the short answer is no. There's a different epidemiology between plague and coronavirus disease.
The second question, Edmund, that's come in that's again on notifiable disease is this. As a matter of general principle, do you think that where there's a specified list of notifiable diseases as at the date of the policy, that the proper construction is going to be that cover's limited to those, or rather on the other hand, to any diseases that are added to that notifiable list in the course of policy?
I think it's creative thinking to consider whether you could imply such a term. But again, I think the short answer is no, because such an implied term would have such a wide-ranging impact. No court is going to imply that into the policy. Where there is the time been taken by the parties to set out a list, it's only going to be those things that are included in the list that are included within coverage.
It's also interesting to note that some policies which have a list in the definitions section just come to the end of the list, and other policies below the list actually absolutely make it clear that the list is definitive. So in those policies, the question couldn't possibly even be argued.
Yeah. Two questions that I think I probably should take myself. The first is on the question of whether or not for non-damage denial of access, a policyholder might succeed, for example, in a hospitality environment, a public house or a hotel, on the grounds that the public can't use the conveniences, whether that is within a clause which provides, as is not untypical, defects in sanitary arrangements. My own view on that is that won't work. And the reason I think it won't work is the word defects. In almost all aspects of insurance law, that word is interpreted to mean a physical defect rather than a limitation on use. A second one that I'll take before handing over to Neil, probably for the final question, is a question which says, well, what will constitute hindrance in the use of premises? Now, that's obviously a question of fact and degree. In my view, that will depend very much on the nature of the premises that are insured. A restaurant, a hotel, a gym may be very different to, for example, an office block. I do happen to know that the Heron Tower, for example, in Insurance London is closed. And that's because a lot of the offices can only in practice be accessed by travelling up 20 floors by lift, and social distancing is impossible to maintain in a lift. So you could even find that there was a hindrance to access, it seems to me at least, for floors above, say, 8 or 9, but not in the floors below. So very fact specific. Remember, it's about access to premises and not use of premises that the traditional wording attaches to. Neil, we'll give you the final word, and that's a question on the Orient decision. What are your thoughts on whether or not the Court of Appeal would be interested in an appeal on that point, and whether or not they might find that it was indeed fair and reasonable for policyholders to be indemnified in respect of losses arising from an insured peril in circumstances where there is a concurrent wide area cause for the loss?
I think, and it's always a hostage to fortune, that the Court of Appeal will be very interested in that. Lord Mance, before he retired from the Supreme Court, said on more than one occasion that he thought that the but-for test should be either given a wide interpretation or should be set aside for another more convenient test. And when one looks at the way that the London market is dealing with this issue away from litigation, it's clear that it's not only academic commentators, but also insurance practitioners who think that perhaps the writing is on that wall. I would put the odds at, excuse me, at least 60% that the Court of Appeal would reach a different conclusion, and that there would be cover insofar as it was within the wording of the policy.
And we all know how much insurers like percentages attached in their opinions. Ladies and gentlemen, thank you very much indeed for your time. Even while we've been answering these questions, there have been several more questions that have come in that we will endeavour to respond to in writing. One of them, for example, is about the approach to the FCA, and there's been some obviously interesting discussion about the extent to which high-level principles of treating customers fairly will come into play here. We will give those some thought. We appreciate the time you've been given in this beautiful afternoon here in London to listen to us, and we look forward to seeing you in the near future. Thank you very much.
Thanks. Goodbye.